Do we have all the participants for the second session? So Dita Čolakova, Ivana Vrkatić, and Ďorđe Timotijević, are you all there? Hello, Dita. Ivana, Ďorđe, are you two here?
Yes, I am.
Okay, wonderful. So we could get started with our second session, so the position of women in ancient Greece and Rome, and our first presenter is Diта Čolakova from the Masaryk University Faculty of Law, and her topic is Rights and Duties of Women in the Roman Law of Succession. I have granted you presenter rights, so if you have a presentation, you can use it. The floor is yours.
Thank you very much. Good afternoon. Please give me just a second. I'm gonna share the presentation. Oh no, here. So, dear ladies and gentlemen, thank you. Dear ladies and gentlemen, I would like to present to you my paper, which is called Rights and Duties of Women in Roman Law of Succession, analysis of the 28th fragment of the fifth book of the second title of the digest. The main aim of this paper is to present the legal position of women, how it differed from the legal position of men in certain specific aspects of Roman law of succession. And the accent is given to the classical period of Roman law, which was approximately from the 1st to the 3rd century AD. So as is perceptible from the title of the paper, it deals with a particular fragment. Here you can see it. It's fragment from classical lawyer Paulus. He was one of the most important classical lawyers, which is emphasized by the fact that 1/6 of the digest is derived from his work. And as for the context of this fragment, the second title of the digest deals with unjust testaments. I'm going to get to that later. So based on this fragment contains a case, and in this case, a woman, drew up a will in which she appointed other heirs, but not her son. She omitted him in her testament. Based on this fragment, we can ask various questions or aspects that I'm going to present. So first of all, it's a matter of testamentary capacity of women. Under what conditions could women draw up wills, and what were the differences with the conditions of men? Because as you probably know, women had worse position in general in Roman law, and it was in various legal transactions. The second aspect that I'm going to be talking about is the matter of compulsory heirs, whether we can talk about this term when it comes to women at all, and what means of protection did the children have based purely on the cognatic kinship, based purely on their blood relation with their mother. Because in general, the type of family relation that mattered in Roman law, that predominated, was the agnatic kind, the one that was derived from the male lineage. And last but not least, I'm going to be talking about the emperor decision, because this case was decided by the emperor, and I'm going to be talking about the reasoning behind this particular decision. So first we get to the testamentary capacity of women. Some conditions were quite the same as the conditions of men. So women were able to draw up a will when they were of full age, when they were Roman citizens or Latins, and when they had full legal capacity. The last point was quite complicated when it came to women, because earlier some women didn't have the full legal capacity for their whole lives. It was because earlier, most of the time of the Republic, the common form of marriage was marriage cum manu, marriage with the power of the man over women, and therefore a woman went from the family of her father directly to the family of her husband. She was always under the power of a man, and therefore was never able to draw up a will. In the classical period, the common form of marriage were already sine manu marriages, marriage without this power of the husband, and therefore it was possible that the woman was married and at the same time she had full legal capacity, which meant that there were a lot of women who were of full age who were able to draw up wills in the classical period. It was about 60 or 70% of women. As opposed to men, they also had to have a consent of their tutor to draw up a will. However, already in the classical period, by some this was already considered an outdated formality, for example by Gaius, and later it went out of use during the 4th century. And also in the classical period, the consent of the tutor could have been enforced in most cases. A very interesting rule, or at least my point of view, is the rule that a woman had to go through a coemption to gain the testamentary capacity. What was a coemption? Coemption was a kind of a fictitious sale when a woman was sold by her family to her husband. It was usually used to enter into a marriage cum manu. So why was this needed in order to gain testamentary capacity? Well, when a woman became sui juris by the death of her pater familias, she was sui juris. She was no longer technically in any agnate family. However, her former agnatic relatives or wider agnates still had some rights when it came to this woman. For example, rights in the intestate succession. So it was quite disadvantageous for this woman to be able to draw up a will. Therefore, with this coemption, these wider agnatic bonds were cut, and the woman therefore was able to decide about her estate as she wanted. This was quite complicated, and of course, after a woman went through coemption, she was married cum manu, therefore she was no longer sui juris and was not able to draw up a will. So it was very impractical. And later, at the end of the Republic, an institute called fiduciary coemption was developed. This made this process a whole lot easier because after the woman was fictitiously sold, she was freed. And therefore, after the fiduciary coemption, she was sui juris and with testamentary capacity and therefore able to draw up a will. This was, however, still a formality, and it was abolished on Hadrian's order. It is not clear how wide the exceptions were that Gaius mentions in this fragment. Of course, there were still virgins because they were quite specific in the matter of legal capacity in general. And when we look at the purpose of this institute, that it had to break the wider agnatic bonds, then we can assume that women who did not have these wider agnatic bonds, such as freed women or women who were emancipated from paternal power, did not have to go through the coemption in order to get testamentary capacity. So now we're getting to the second aspect of my presentation. In the analyzed fragment, son was omitted in the testament based on the fact that the mother thought he was dead. In this fragment from the institution, we can see a rule that a mother is not required or obliged to mention her son or her children in testament. And this rule was already known in the classical period because Gaius mentions it as well. So what does this mean? Well, technically it means that women had no compulsory heirs. However, already at the times of the Republic, it was considered moral and just and also common that the parents passed on their estates to their children. And in the classical period, this was already a legal rule. So therefore, the children had some legal protection based purely on their blood relations, which emphasized the importance of the blood relations in general. What means of protection did the children have based on the cognatic relation? Well, it was querela in officiosi testamenti. That was a claim usually used by compulsory heirs who were omitted. But in the analyzed fragment, the son used another way. He decided to turn to the emperor so that the emperor would solve the case. It was quite an advantage for the son because it made his proving and his argumentation a lot easier. He probably argumented that the mother only omitted him in the testament because she thought he was dead. If he would have used querela, he would have to prove that the mother breached officium pietatis, that was the natural family affection, and also that she was not quite sane at the time when she wrote the testament, which would not have been very polite or nice to her commemoration. Another disadvantage that would come from using querela would be that after the testament would be invalidated, there would come the intestate succession to place, and therefore the son would be an heir first in the third brother's inheritance class because he was purely a cognate. So the case was decided by the emperor, and the estate went directly to the son. However, he had to fulfill the wishes of the mother concerning manumissions and bequests. Why did Hadrian decide it this way? Well, partly it's connected to the fact that what I already said. At this time, in the classical period, it was already considered moral and common that children should get something from their parents. And Hadrian presumed that if the mother had known that her son was still alive, she would have made him her heir. Therefore, the will was invalidated due to the error and inducement, not because Hadrian considered the will unjust or inefficacious, like it would be if the querela was used. The rule that the error and inducement can invalidate a will is still in the contemporary law, and it's an exception to the general rule that inducements have absolutely no legal matter in private law legal transactions. But back to this decision. Why did Hadrian decide this way about the manumissions and the bequest? Well, it connects to the principle, to the most important principle of Roman law of succession, which was that the true intention of the testator should have been fulfilled as much as possible. And Hadrian presumed that if the mother would make her son her heir, she would decide about the manumissions and bequests quite the same as she did when she appointed other heirs. And as I already said, the testament was not considered unjust, and therefore Hadrian felt no need to diverge from the wishes of the mother when it came to manumissions and bequests. So to conclude, when it comes to the testamentary capacity, after fiduciary coemption went out of use, and also after the tutela mulierum was abolished, the position of men and women when it came to drawing up wills was comparable. It was after the abolition of the tutela mulierum, it was quite the same. They were able to draw up wills under the same conditions. Throughout the whole history of Roman law, women were disadvantaged by the agnatic character of Roman family, and there was a development in favor of the cognatic relations, in favor of the importance of blood relations as well. And a sign of this development was, for example, the development of brother's third inheritance class. It also carried a duty within it to leave some estate for the children in a will. And in some cases, the realization of the importance of the blood relations could also have an impact on the interpretations of wills in accordance with the true intention of the testatrix, like it was, for example, in the analyzed fragment. So thank you very much for attention, and I'll be looking forward to your questions in case you have any. Thank you.
Thank you very much, Dita. This was a very interesting presentation and perfect timing. So our next presenter is Ivana Vrkatić from the University of Belgrade Faculty of Law, and her subject is the legal position of concubines in Attic law. Ivana, do you maybe have a presentation?
I don't have presentation.
Okay.
Can you hear me?
Yes, we can hear you. So please go ahead.
Thank you very much. As Nina said, I will talk today about legal position of concubines in Greek law. Concubine in Greek law was denoted by term palake, while the word palakai was used for concubinage. The sources do not define in detail what the term palake means and when it refers to. In etymology, the word palake is considered to have similarity, or we can say has the same etymological origin as the Latin word pelex and the Hebrew word pilagesh, and both words means mistress. In all three words, there is a root lex, which means to lay down, and the basis of this is to conclude that they have the same etymological origin. It is assumed that all three words originate from a lost Indo-European language, which was certainly not Proto-Greek. So sources abound in information about concubines, but depending on whether the text of source refers to Greeks or Persians, the term palaki has a different meaning. In the sources that write about Greeks, palaki means a woman with whom a man has extramarital affair, which usually lasts, and from that relationship can be born offspring. In sources about Persian, especially in Herodotus' history, the term palaki generally refers to a woman from the harem who came to this position in captivity. The oldest known mention of the term palaki is in Homer's epics. In the Iliad, this term means mistress, or a woman with whom a man has a love affair despite being married, and in Odyssey means a Persian slave with whom a free man had a son and respected him as well as a son from a legal marriage. Since most sources about palaki come from the area of Attica, the topic of my work is therefore focused on the study of position of concubines in Attic law. Through the research of their legal position, I also researched their social position in Athenian polis. At the beginning of the research, I asked myself the question, who were the concubines and what was their social status in Athenian polis? We can say it with certainty that the concubines were mostly of foreign origin and the most of them were slaves. That means that they entered concubinage involuntarily. However, there were also free concubines of foreign origin who consciously and voluntarily entered into a relationship of concubinage. Such free concubines most often came from the ranks of courtesans or hetaria, well-educated women, or prostitutes. And there was possibility that after concubinage ended, they would become courtesans and prostitutes again. There are also theories that free female Athenian citizens could have become concubine, but I will talk about that later. Both marriage and concubinage represents a long-time partnership or relationship of man and woman from which offspring can arise, but there are several significant differences between them and that I will now list. Unlike marriage, which was conditioned primarily by formal procedures, concubinage began with informal cohabitation of two people. Also, only citizens could marry because the procedures for marrying were available only to citizens. There were two procedures, engie and epidikasia. Engie was the contract between the bride's father and the groom, and epidikasia was the procedure for determining the husbands of the Epiclera. Professor Sima Avramović will talk about that tomorrow, I think. And difference between marriage and concubinage is also the dowry or proix. The dowry in Attic law was not necessary legal condition for marriage, but it was very desirable, and giving a dowry became a custom. However, as much as the dowry was desirable, and on the other hand, receiving the dowry was a limiting factor for the groom, because he had to return dowry to the wife's family upon divorce, and since the value of dowry was not small, husbands did not easily renounce it. It is possible that some men remain married only because of dowry. Athenian girls who came from the poor families who could not provide dowry, they most likely become concubines because they were not attractive enough to get married. Of course, this is a theory because we lack reliable data from sources that can support this theory. On the other hand, a dowry was not required for concluding a concubinage, and upon its termination, the man did not have any financial obligations toward his ex-partner. And the last difference between marriage and concubinage is that children from marriage have always had possession of the legal heirs of their father. Creating legal offspring was one of the basic duties of every Athenian citizen. Inheritance in Athens did not only mean inheriting property, but also inheriting the cult of ancestors, which could continue the life of the oikos. And only legal heirs could do that. The legal status of children from concubinage has changed over the time. Until Pericles Citizenship Law in the middle of the 5th century, children from concubinage could be declared legitimate if their father recognized them. Pericles' law introduced the novelty that a citizen is only a person who comes from the marriage of two Athenian citizens. And after adoption of this law, the offspring from the concubines were automatically considered illegitimate. Children were considered nathoi, and such children had no inheritance rights, nor status of citizenship, and their legal position was similar as metics. The legal position of children from concubinage greatly influenced the legal position of concubines, and the most important source about this is Dracon's law or lawful murder. I will now quote this law. If a man kill another unintentionally in athletic context, or overcoming him in a fight on the highway, or unwittingly in battle, or on or beside his wife or mother or sister or daughter, or concubine kept for procreation of legitimate children, he shall not go into exile as a manslayer on that account. The most important goal of this law in the context of family relations was to acquit the Kyrios. Kyrios was a man under whose protection a woman was, and that could be father, husband, or brother. Kyrios was acquitted, although he killed person caught having a sex relationship in flagranti with woman who was under his protection. However, it is not clearly defined whether these sexual relations were voluntary or not, so it can be assumed that this provision also includes adultery, seduction, and rape. Another no less important reason for passing this law was to ensure the legitimacy of the civil offspring. An analysis of the law leads to the conclusion that it applies only to the women who are under protections of Kyrios, and those were wives, mothers, daughters, sisters, and concubines. The law does not cover slaves except those who had the status of concubines, the foreign women, as well as women who were engaged in prostitution. The law does not deal with women's consent at all, but she is only an object of sexual assault. Essentially, the law refers to the Kyrios and his rights, not the rights of the victim. The concubines, although mostly of foreign origin, received the same level of criminal protection under the draconian law as a female Athenian citizen. This privileged position of the concubine stemmed from the fact that her offspring could obtain status of Athenian citizen if the father, an Athenian citizen, recognized him. As a result, any sexual intercourse between concubine and a man who is not her extramarital partner was punished, so as not to call into question the child's origin. The Pericles Citizenship Law was relaxed at the request of Pericles himself in 430, because in Athens there was a sharp decline in the number of male citizens due to the Peloponnesian War and the plague that took over the polis. A kind of amendment was adopted which allowed the father to adopt a legitimate son if there were no surviving legitimate descendants. However, this mitigation was abolished at the end of the 5th century BC because in the speeches for the 4th century BC, only children who come from a legal marriage are considered legal children. The enactment of the law did not lead to the abolition of concubines, but the position of concubines certainly changed, especially in 4th century BC. They had no longer criminal legal protection, and their social position was approaching to the prostitutes. I quote from Demosthenes, points us to this: mistress or hetaria we keep for the sake of pleasure, concubines for the daily care of our persons, but wives to bear us legitimate children and to be faithful guardians of our household. I think that concubines were very attractive to Athenian males because they were different from Athenian women. Most of them, they were like exotic because they were educated, they had different lifestyle, and concubinage existed all over the time. That is from me now. Thank you very much.
Thank you very much, Ivana, for your interesting presentation. And now for our third and final speaker in this session, Ďorđe Timotijević, also from our faculty, and his topic is the legal standing of women in ancient Athens. Ďorđe, I'm about to make you the presenter in case you have a presentation. And either way, you can start speaking.
Thank you. Good afternoon. As the professor said, I'm going to speak about legal standing of women in ancient Athens. So this paper will cover legal standing of women mostly through the Athenian laws governing marriage, adoption, inheritance, property transfers, the treatment of orphans, and generally the protection of women who were legally unable to aid themselves. And therefore, this paper will cover the laws of the most important Athenian lawgivers, Draco, Solon, Pericles Law and Citizenship, women's oikos, contraception and abortion, property, and other careers they could have undertaken. So Athenian authors of the classical period imagine a mythical past where women were subject to similar restrictions in their legal standing and social roles as in their own time frame. And Greek drama amply portrays female characters in the settings of Mycenae, prehistoric Thebes, or Athens at the time of the kings. And those women resemble Athenian wives, concubines, mothers, sisters, or daughters in their roles and obey or disobey the same social conventions as 5th or 4th century Athenian women. But in reality, very little is known about the legal or social position of Athenian women until the time of Draco, who was the first lawgiver of Athens. And it is widely agreed that Draco provided Athens with its first set of written laws amid widespread social discontent in 621 BC. His legislation should probably be seen as an attempt to curb some of the excesses of the ruling aristocracy and firmly establish the rule of law over the will of powerful families. So much of the legislation of Draco was superseded by later statutes, but his homicide law, which remained valid throughout the classical period and until the end of the Athenian polis, introduces very firm regulations on male conduct towards free females under the authority of another man. And the law of Draco on justified homicide permitted a man to kill another man caught with his wife, mother, sister, daughter, or concubine, that is, any woman under his legal protection. And by doing so, these laws actually set several important legal definitions which would remain in force for centuries. First, the law of Draco probably enshrined into the letter of the law the existing concept of what is a family. And by naming the female members of a man's household, this law defined the family as a wider unit, encompassing all free females. Slaves belonged to the family, if not as persons, at least as valuable property, and this widely defined entity consisting of all the persons that lived in a household and all its assets was called the oikos. And the oikos was probably a very old concept, and despite some changes in its character and legal standing over time, it remained a constant in Greek life. And the second major implication of Draco's homicide law was the recognition of the sanctity of the family and family life. So no matter how powerful or influential a person was, he still did not have the right to enter someone's house and seduce or force the women under this man's authority, for the law provided the most efficient deterrent, which was self-help. So the wronged man would not need to seek justice elsewhere, and he could avenge his injured honor there and then. And it seems that from early times the Athenian state made a firm commitment to protect the family and all individuals in it. The main reason behind it probably was the fact that the state had vested interest in the continuation of the citizen stock and the upholding of traditional values, and saw the family as the custodian of these important matters. So the legislation of Dracon was largely replaced by that of Solon, a generation later in 594 BC. Solon considered carefully the role of the family in the institutions of the state and was the first to introduce extensive social legislation. And he probably introduced the laws that covered marriage, adoption, inheritance, property transfers, and generally the protection of the weaker members of society. And it is also possible that Solon enshrined into law the concept of succession only by legitimate heirs, namely natural sons or daughters properly born in wedlock, or adopted heirs in the absence of natural legitimate sons. And moreover, he introduced laws on the orderly conduct of women, some of which were seemingly not enforced in the classical period. And Solon probably introduced milder laws regulating cases of adultery, such as permitting the husband to abuse the seducer with impunity or accept financial compensation in order to provide alternatives for the atonement of the injured man's honor without the need to resort to murder. In the same spirit, and in order to curb abuses of the draconian adultery laws, he introduced a law which stated that if a man is caught with a woman who practices some form of prostitution, either organized or freelance, he cannot be accused of adultery. By doing so, Solon perhaps unintentionally legalized and defined prostitution, but any woman who offered sexual favors for money placed herself outside the protective shield of the oikos. And the introduction of the democratic constitution in the late 6th century BC does not seem to have affected significant change in the role of the family or the position of women in it. But one major change was introduced by Cleisthenes that affected only males of citizen status. So now they would need to register with a deme rather than the phratry in order to enter the citizen body, and the phratries were traditional institutions with religious connotations. And Cleisthenes bypassed them when he introduced constitutional reform, nowadays known as moderate democracy, and he set up the deme as the basis of public life, a rather secular and more egalitarian institution. But however, women were excluded from the demes as they did not participate in war and politics, and certainly non-citizens and slaves were also excluded. The democratic constitution was intended to broaden the basis of participation in public life as much as possible, but of course it would be unthinkable for women or slaves to be included in the ancient world, while the exclusion of resident aliens from politics still remains universal practice to this day. And the first major change in the definition of the family under the democratic constitution came in 451 BC. When a law introduced by Pericles stated only the offspring of two Athenian citizens could be citizens, but the actual content and the intention of the law have been intensely disputed in recent years. However, Aristotle is probably right when he says that Pericles wanted to reduce the number of Athenian citizens. When this law was introduced in the height of the Athenian Empire, when the city was the center of the Hellenic world, and being an Athenian citizen meant to participate in decision-making that affected the areas as far away as the Black Sea or the shores of Italy, but of course, women did not participate in this decision-making. First, this law practically limited the marriage options of Athenian men to Athenian women, and less than a century later, in the first quarter of the 4th century BC, the state went one step further and prohibited Athenian citizens to marry foreigners and imposed severe penalties for the pretense of lawful marriage between an Athenian and an alien. Second, the Periclean law formally recognized Athenian-born women as citizens in their own right and sanctioned their role in the continuation of the citizen body. Women until then were participants of the polis only in the sphere of religion, when they could hold priestly offices, perform ceremonial duties in public gatherings, but after the Periclean Citizenship Law, Athenian women are recognized as participants in the state, even if not fully, and this comes with certain obligations. So until then, only the male party was considered legally responsible for the seduction of free women. However, probably not long after the Periclean Citizenship Law, another law was introduced requiring the husband of an adulteress to divorce her under the penalty of disfranchisement if he disobeyed, and imposing a ban from all public temples upon the adulteress herself. For the first time, the woman would be held personally accountable by the law and deprived from her privileges in public life if she misbehaved. And by turning the spotlight on Athenian mothers, the state was determined to protect the legitimacy of children born in Athenian families and make sure that those who receive citizenship truly are of citizen stock. After the Periclean Citizenship Law, a child will be of citizen status only if both parents were citizens, as I already said. However, since the Athenians did not keep birth records, citizen identity was conferred upon the child gradually, and it would mean different things for boys and girls, because a boy would be presented to the members of the phratry and possibly the genos or other such associations to which his father belonged not long after his birth, but after the reforms of Cleisthenes. Membership of these bodies was not an obligatory requirement for citizenship, but most Athenians belonged to them, and failure to present a legitimately born citizen both to these bodies might give rise to questions and later prejudice his registration with the deme. But for women, the process was considerably different. There is some evidence that girls could be presented to the phratry, but this was not obligatory, and some Athenian men might not even bother presenting their daughters, as this had no real legal significance. And this is why the evidence for presentation of girls to the phratry is rather sporadic. Girls were educated at home and were taught how to become good mothers and prudent housewives, how to count, and in some households how to read and write. And when the time came, ideally while still in adolescence, they were given in marriage to an Athenian man, and they were not registered with a deme. Precisely because it was not easy to disprove objectively a woman's citizenship status, the state felt the need to introduce some safeguards in the early 4th century BC, and the law imposed severe penalties upon a man who had tricked another man into marrying an alien woman by assuring him that she was Athenian. So the position of numerous aliens living in Athens, which were metics, differ from the position of the Athenian citizens or slaves. They could not vote or be voted into office, but their property rights were protected, and then they could represent themselves in court, although in certain procedures they needed to use an Athenian agent. And marriages between metics were legally valid unions, while their person and sanctity of family life were protected by Athenian law. Non-citizens could not own real estate unless given this right through a special resolution for good service for the state. And the large slave population of Attica was mostly under private ownership, except for a small number of public slaves. They had no rights and had only limited protection against abuse or injury. But a mistreated slave could always ask to be sold to someone else, but besides that, he or she would be completely at the mercy of the master. Slaves were a valuable commodity, and an injured or disabled slave would be no good, as she could lose much of their value in this case. So attractive female slaves, both for the purposes of practicing prostitution, would be groomed and could be very expensive, and slaves kept as concubines might be treated with generosity and enjoy certain privileges at the discretion of the master. And unions between slaves and procreation were possible if the master permitted, and a 4th century BC Xenophon essay on good household management recommends allowing good slaves to have families, as this would make them more cautious and more trustworthy. And a slave could be set free by the master as a reward for dedicated service, or sometimes he, or in this particular case, since we're dealing with women, she might be able to negotiate with a reasonable master as him, whereby after a number of years of faithful service and hard work, they could gain their freedom. Sometimes a slave could be set free under the condition that she would stay and work for the master after liberation for a stated period of time, which was called paramount. Slaves were treated as human beings at their death, so religious scruple demanded the punishment of a killer of a slave, unless of course it was the master, and some burial rites were in order even for the lowliest slave. So a respectable woman's place was at home. There she should look after her children and her family, take care of the household, delegate duties to her servants, guard the property of the family, and make sure that domestic life runs smoothly. And if a good wife had performed her duties properly, her husband would not need to worry about family matters, and he would be able to take care of the affairs of the outside world and act as the representative of his oikos in the polis. Ancient authors frequently state that a man's domain is outdoors, while a woman's domain is indoors, and the leading male of the household, who was called Kyrios, had the legal duty to represent in court cases the members of his household, such as women, children, and slaves. Other adult males of the household, such as unmarried brothers, retired father, were legally independent, but they were all in control of the Kyrios, because he was the one in charge of the family property, so women weren't in charge of property. The Athenian Kyrios did not have a right of life and death over the free members of his household, with the exception of newborn infants, who had not been yet formally acknowledged and thus recognized as a free person with certain rights, but in reality that would rarely happen. So fathers had the right to have a newborn killed, but that didn't happen quite often. Unwanted births could be controlled through contraception and abortion, but both procedures were neither safe nor foolproof. Athenian law said nothing on either contraception or abortion, presumably because Athens, like most Greek city-states, preferred a rather limited and manageable population, and therefore had no good reason to resist them. such practices on a collective scale. In fact, Plato and Aristotle recommend abortion in a utopian state as a method of population control. But however, in the early 4th century BC, one case over an induced abortion ended up in court as a homicide procedure, but it seems that it was a long shot that led to nothing. Athenian women could attempt contraception and abortion without fear of the law. Contraception, of course, would be safer, but unfortunately, since the ancient world did not exactly understand how the process works, contemporary contraceptive methods often were nothing more than wishful thinking. And abortion might appear to be an inescapable necessity and a last resort, especially for prostitutes, unmarried women, and women who had conceived outside wedlock or with men other than their husbands. The Hippocratic corpus contains plentiful advice on oral drugs, pessaries, mechanical methods, and even a surgical procedure in order to induce an abortion, but this advice was supposed to be used for therapeutic purposes only. However, it was used for abortions dictated by a wide range of circumstances. In fact, the author of the Hippocratic Study, The Nature of the Child, describes how he helped a musician and expensive companion of rich men to have an abortion, and he does so with any concern of the moral implications of the case. And the Hippocratic Oath, on the other hand, took a firm stance against abortion, and it banned it completely, probably because its author felt the doctor's primary duty is the preservation of life, not its destruction. Abortions for aesthetic reasons do not seem to be a Greek phenomenon. Athenian women took pride in motherhood, and they drew prestige and social status through their role as wives, mothers, and matrons of households. Better off women might enjoy the luxury of a rather leisurely life at home, and they were able to dedicate all their energy to the care of the family and household, and socialize with female friends and relatives. And on special occasions, they would dress up and go into town or to a sanctuary, participate in a festival, and celebrate with the rest of the community. Of course, Athenian housewives were financially dependent upon their husbands unless they were widowed with young children. In that case, they could choose to remain in the house of their deceased husband and take on the responsibility for the family assets. Occasionally, they might need some help from male relatives in their transactions with the outside world, as respectability would not allow them to go to the financial centers of Athens and directly deal with strange men. So women from rich families would normally bring a large dowry into their new household, which would then be managed by the husband, even though he never owned it and had to return it in its entirety in case of a divorce. And the dowry was not a legal requirement, but it was a strong social convention, and even poor people would still try to scrape together a small dowry for their daughters. The dowry was a standard route through which a woman inherited part of her father's property if he also had male children. If the woman's father had no male heirs, she inherited the whole of his property and became an epicleros. The law of the state intervened in that case and ordered the closest male relative of her father in order of seniority to marry her and take control of the property that came with the woman. If he was already married, he could divorce his wife and marry the epicleros or pass on the epicleros to the second closest relative, and so on. If no relative wanted to marry the poor epicleros, the archon, the senior magistrate of the state who was in charge of social affairs, was legally bound to compel the closest male relative of her father to provide her with a dowry of his own and find her a husband. The laws regarding an epicleros have attracted a lot of attention in recent years and have often been interpreted from a late 20th century point of view as a demonstration of complete disregard for the woman's feelings and wishes. And so, like an object, she was to be whisked around until a man was found to take her and her property under his wing. But this is not how Athenian eyes would have seen it. The Athenians said did not want to have stray single females around, because then someone would need to take over the responsibility of looking after them, and women could not represent themselves in court. Most of them did not have skills to earn a comfortable living independently, and many would be unprepared for their upbringing for the trappings and for the difficulties of the outside world. So this is why the state, with clear legislation, made certain that no freeborn female would be abandoned to fend for herself in a harsh world, and the institution of the epicleros was established to protect her. And the Athenian state trusted that her father's closest male relative should be the most suitable man to do just that. And the fact that the woman might not love a husband imposed upon her would not be considered important by most Athenians. Normally, marriages were not based on love, but on the prospect of a good relationship for the future. And love and respect between husband and wife were hopefully going to develop as time went by. But then again, if we judge from the extremely low divorce rate in Athens compared with the soaring divorce figures of our times, perhaps we may become less critical of this kind of Athenian attitudes towards marriage and towards family life. So for less well-off women, some of these rules and moral standards were not applicable, and they often needed to work in harsh conditions in order to support their families. And it would be easy for a financially comfortable matron to seek a respectable life away from the crowds. So if the husband of a poor woman was dead or away on military service and she had no rich relatives to support her, she would need to become the man and the woman of the household. She would need to feed her children, take care of their upbringing, and she would need to face all the pressures that working single parents with a modest income had to face throughout history. And job opportunities for women were limited, and those that existed were to be found mainly in the health sector, small businesses, petty trading, and small-scale manufacturing. This is why some found it easier to follow the path of prostitution with its other rewards, but as well its many dangers. So male and female prostitution was permitted by Athenian law and treated in a similar manner as other disreputable but necessary jobs. So male prostitutes should refrain from advising the assembly, accept certain offices, or serve as one of the 9 archons, but otherwise they could live as they wished. And the freelance prostitutes had a higher chance of a better life, as they could make more money, regulate their working hours, and take control of their lives. And high-class prostitutes, the famous hetairae of the ancient world, they live a life of wealth and luxury while they were at their prime, and had a much better chance of finding someone willing to take them as concubines and allow them to live their mature years in respectability. So unlike most women in the ancient world, these hetairae received an education, and they were given long lessons on good social skills. So some of these women played an important role at the side of influential men, while some others were the only women in the ancient world who were able and willing to live independently without a man at their side. And if they were freeborn or liberated from slavery, they could put aside some of their earnings, amass a large fortune, and then spend it as they fancied, and they were not limited by the boundaries which respectable women had to observe. So we can see that the position of prostitutes differed from the position of ordinary women who had to fight in the Athenian states and had to work in hard conditions so they could support their families. But overall, the position of women in ancient Athens didn't differ much from the position of the women in other Latin civilizations of the ancient world. So we can say that that overall the position of women wasn't that bad, but of course it had its limitations. But with the Pericles law and with the laws of Dracon and with the laws of Solon, those laws certainly helped and made the position of an ancient woman, of course, of the Athenian women, better. That would be about it. Thank you.
Thank you very much, Ďorđe. So this ends our second session, and I'm opening the floor for questions. Are there any questions for any of our 3 participants?
Well, I would have a question for Dita. As you were speaking about autoritas tutoris, why was this left in the late days of the Roman Empire?
Well, can you hear me? Yes. The reasoning behind this institute was because women were considered, well, how to say it, more fragile than men, and they needed more protection. And well, I don't know. I suppose that this opinion just lasted longer, but still, like I said, the consent could have been enforced in loads of cases, and therefore the institute wasn't. It was merely a formality at the end.
Thank you.
Thank you. Any more questions? Anyone else?
I would like to ask if there is no other question.
Yes, please.
Moment to start video. Yes. I would like to thank you. All three papers are very interesting, but of course I would like to ask something our colleague Dita Čolakova, having in mind that spoke about issue in Roman law. So having in mind that Papinianus, a very well-known jurist, said that in many provisions of our law, the position of woman is worse than of men. What is your, Dita, personal opinion if the position, legal position or factual position of woman in Roman law was more, how to say, if was a woman in Roman law more had the position of subject or object of law? So taking all circumstances into account.
Thank you for the question. I think woman was definitely still a subject of law, not an object. I mean, Roman law developed a perfect way of a person being an object, but that was only related to slaves. Of course, slave women were objects, but usual women were still subjects. But still, the Papinianus fragment, it's true that the position of women was truly far worse than the position of men, but it doesn't mean that they were objects. And I don't want to talk about the position of women in general, because I was focusing on these particular aspects. And in these aspects, well, like I said, in some cases, the legal transactions were conducted in the same way, like, for example, the drawing up of wills. But in some cases, until the very end of the development of Roman law, the position of women remained worse. If that answers your question.
So we must take, thank you very much, we must take into account this sentence of Papinianus, who is somehow a pioneer, maybe in ancient times, of a supporter of a better position of women in general. Thank you very much.
Thank you. Any more questions?
Can I ask something?
Yes, of course.
Ivana is here. I have one question for Đorđe. In the beginning, I want to praise him. His paper was very good. The theme is very complex. And Đorđe, what do you think? Why is adultery was more severely punished than rape?
But what is adultery? Can you repeat?
A woman's adultery.
What is adultery? Yeah.
Why is more severely punished than rape?
Well, adultery, yeah, it was.
Do you think about that?
Than rape.
Yeah.
I don't know.
No? Do you?
No, I was just speaking about adultery, but rape. But in terms of adultery, well, yeah, I don't know. Perhaps the Athenian state they wanted to protect the women more than men, so, and they punished the adultery, like. Rather than rape. Why? That's a really interesting question. It doesn't occur to me why they would need to do that. But
okay.
Well, if I may jump in on that regard, as far as I know, one of the theories is that the primary object of protection there were men and not women, as was just implied. So essentially, it was believed that a man whose wife is, say, raped is not as insulted as the man whose wife had committed adultery, because in the case of the rape, the wife did not betray her husband. She was forced to an unpleasant but temporary act, while in the case of adultery, she also betrayed her husband in some way, and it's even a worse crime on the man's, meaning the adulterer's behalf, because he didn't just temporarily make sexual use, so to speak, of another man's wife, but he seduced her to stop loving her husband and start loving him, and so on and so on. So a very male-centered perspective.
Yes.
See, that didn't come to my mind, but thank you for the answer.
And while we're there, I might have a half comment, half question for the two of you, since it's an issue that you've both mentioned, and that's the Solon's law that allowed the offended Kyrios to kill, again, a man caught with his sister, mother, wife, or concubine, which, as Ivana has already said, could cover either adultery or rape. But you said, of course, from a point of view of writing about concubines, that the main motivation of the legislator might have been the protection of legitimate offspring, since in that period they could come also from concubines and not just wives. But since that same law also allows the man to kill a man caught with his unmarried sister or his widowed mother, in that case we can't say that it protects legitimate progeny, because obviously an unmarried woman could have no legitimate progeny. Any child she gave birth to would be illegitimate. So again, in that case, maybe we have more of an angle of protecting the man's honor, because a woman under his authority, a woman that he was in charge of, so to speak, had been seduced or violated by another man, and he could not stop it, he didn't know about it, and so on. So simply, what do you think about that angle?
Well, I think that... are you going to answer, or... I don't know. I just wanted to say that I think it's a great accomplishment for Athens that it permitted a husband to abuse the seducer with impunity, or he could accept compensation, and that gave him a choice. So there was no need for him to resort to murder. So there was no need for him to kill the rapist. So I think that was a good accomplishment. Just a comment.
Okay, Ivana, you wanted to say something?
Yes, I want to say in draconian law of lawful murder, there's said that they could kill a man who is caught in flagranti, we can say, with one mother, sister, etc., and palake, who is there for procreation of legitimate children. I think that part of this law is only for palake, and for mother, sister, and daughter is not in this section. We can say there is a honor of Kyrios. In the section of palake is not only honor of Kyrios, but honor of their children of concubines. I hope you understand me, what I wanted to say.
Okay, thank you. Professor Avramović, did you want to say something?
No, I'm just making a comment that I have a problem with my mute button. So it completely changes by itself without my will.
Sorry. So any more questions? If not, we could maybe take a break now. Now, since we have finished a little bit ahead of schedule, Isidora, Katarina, do you want us to wait until 2:30, or would you prefer us to start earlier as you two are speaking in the next session?
We could start earlier in 10 or 15 minutes after the break.
Yes.
Okay, so let's then, essentially this ends our English sessions for today. The next session continues with ancient Greece, but in Serbian. We'll just have the two first participants, Isidora and Katarina. Bogdan has unfortunately called in ill, so we are making a 15-minute break now, and instead of 2:30 at 2:15, we are continuing with the third session. Thank you all very much for your participation.